Hi, my name is Ethan Landy, and I am an attorney with the Department of Labor and Industry's Office of General Counsel. Today I will be presenting on the Rehabilitation Registration Rule updates in Chapter 5220. I will start with an overview of the rulemaking process and status. The bulk of this presentation will then dive into the substance of the rule. A copy of the rule is available as a handout or online, and it may be helpful to have this available during the presentation. You are welcome to ask any questions in the chat, which is being monitored live. The rulemaking process chart on your screen describes requirements necessary for the department to meet the formal obligations of the Administrative Procedures Act in adopting or modifying a rule. This chart highlights the most important steps, though it's not exhaustive regarding the requirements of the rulemaking process. DLI is currently in the Rule and Sonar, or Statement of Need and Reasonableness, development stage. So this is the third step in the process, as you see on the screen. While we are now past the request for comments period, there will be other opportunities to offer comment or feedback on the proposed rules, including when we get to the Notice of Intent to Adopt the Rules part. All rules are also required to be reviewed by the Office of Administrative Hearings and an administrative law judge to make sure they meet the legal requirements necessary. The department's primary goal with these possible rules is to update the current rules to clarify requirements for QRC interns, QRCs, and firms and vendors. The department is also proposing some technical changes related to these updates, as well as some more substantive changes to current rule requirements. I will briefly go over the rules with you this afternoon. Please note that the draft that we are discussing for this presentation was first created for discussion purposes at the July 7th, 2022 Rehabilitation Review Panel meeting. This draft is subject to change as DLI continues through the rulemaking process. While your comments and suggestions are welcome today, I'll point out that as noted in the official request for comments, any information we receive will not be official comments as defined for rulemaking purposes. I'll now move to discussing the actual draft of the possible changes. First, we have some updates and additions to the definitions in Part 5220-0100. This is in the draft in lines 1 through 34. Some of the changes are to cross-reference the new proposed rule parts where the department is proposing rules specific to the type of provider or entity. For example, the cross-reference to Part 5220-1510 in Subpart 23 here is the new proposed language being added for QRCs. We are also including two new definitions, one for a QRC intern and one for an intern supervisor. One of the department's main goals with the possible changes is to outline the requirements more clearly for interns and supervisors in these rules. Finally, in Subpart 28, you will see the first of many changes to the term registered rehabilitation vendor. Because the rules require a vendor to be registered, the department has determined that having that part of the language is unnecessary. So the possible rules remove that in various places. In fact, as noted on the first bullet here, that is the change in the next three sections, parts 0410, 0450, and 0510. These sections are seen in lines 36 through 85 of the draft. The changes to Part 5220-1250 include many examples of this removal of registered as well. This section also includes some cross-references to new proposed rule sections. The substantive changes in this area are to more clearly define the services provided by a rehab vendor and to move a part of the current rules that that will be repealed in Part 1500 on the Commissioner's review of professional activities and services. The services provided by a vendor adds vocational testing and transferable skills analysis as well. We're now moving toward the first new part in the possible rules, which is 5220.1410. And this is the new subpart specifically for QRC intern requirements and requirements for supervisors. This is the first section in the draft proposal that is meant to replace a current rule section, and here is noted that is part 1400. And in the draft, this can be found on lines 128 through 265. As noted here, in the current rules, much of this information is included in subparts under Part 1400 on qualifying criteria for rehabilitation consultant. The department is moving toward a more standalone model for each section to help clarify the requirements specific for each type of provider, in this case, specific for QRC interns. The 4 subparts are summarized on this slide, but I will go into further detail on each. Starting with Subpart 1. Subpart 1 describes the requirements and application information required for a QRC intern. Many of the requirements will be similar to current requirements for QRCs or interns, and should be familiar to those who have previously applied for QRC registration. Current rules do not have much information on what is required for an actual registration application, and so that is being clarified in the proposed rules for all persons and entities. Some items to focus on in this section include the list of requirements for an application, the plan of supervision for the QRC intern, and the timing for when intern registration expires, and therefore an intern would need to have completed the intern requirements. Note that this current draft does not change the fees for application. However, as the department mentioned during the July 7th RRP meeting, this is likely to be updated in a subsequent version for all registration categories. Subpart 2 discusses the approval or denial of an application. This process will be seen in other parts of the rule and is meant to provide uniformity and clarity for the department's process for application review. For instance, this section notes the grounds that may constitute denial of an application. Also, this is the section where the department has inserted a 36-month time period for intern registration rather than the previously used 3 years. Subpart 3 describes the requirements a QRC intern must meet during their internship. This includes a more accurate description of the work the intern must complete that is more clearly laid out. One item to point out is the change from the current rule requiring work for 1 full-time year or 37 hours per week during a 52-week period. The department has recognized that, especially in light of COVID-19, work can sometimes fluctuate. So therefore, the proposal has been broken out into billable hours instead. At least 100 of these billable hours must be in job-seeking skills training, job development, and job placement, and at least 900 must be in services such as vocational counseling, medical management, and labor market analysis. Note also that item L of this subpart on line 243 is the first instance of the rules, also seen in part 1510 for QRCs, allowing for a master's degree in vocational rehabilitation counseling to substitute for certification as a rehab counselor or certified disability management specialist. We will touch on that a bit later. A few more items to point out for intern requirements include that the intern must be the rehab consultant on record for one each of a rehab consultant report, R2 plan Plan Progress Report or R3 Amendment, and R9 Notice of Closure. They also must complete at least one narrative report on vocational testing, a narrative report on transferable skills analysis, and a labor market survey. Finally, Subpart 4 describes requirements for the QRC intern supervisor. If you are following along with the draft mentioned earlier, this can be found on lines 247 through 265. The supervisor is ultimately responsible for the QRC intern's work. Many of the items in this subpart, like attending administrative conferences with the intern and not billing for supervisory work, will be familiar when comparing to current rule requirements. The supervisor also must review any written work that substantively applies to the scope of the rehab plan. One change to highlight here is that a supervisor must have at least 3 years of experience on line 265. The current rule states 1 year, but feedback from experienced supervisor stakeholders indicated that more experience was needed to truly have the knowledge to supervise an intern. We're now moving to a new section, both in terms of the presentation and also compared to the current rules. Part 5220.1510 relates to QRC requirements and registration. There are 6 subparts here, and the section is broken into the requirements for the initial QRC application in subparts 1 and 2, and then the process for renewal applications. Looking at subpart 1, this reviews the requirements for a QRC intern to transition to become a full QRC, and then the information needed to apply to be a QRC. One of the biggest areas where this differs from a renewal application when someone is actually a QRC is probably not surprising. The initial applicant must include documentation that they have complied with the intern requirements in the previous part 1410. Also, the initial applicant must have been a QRC intern for at least 12 months. DLI has found that the required work for the possible rules would take at least a year to complete. This part also includes the 36-month time period to complete the intern requirements. And as noted earlier, this requires proof of certification as a Certified Rehabilitation Counselor, CRC, or Certified Disability Management Specialist, CDMS, or instead a Master's in Vocational Rehabilitation or Rehab Counseling through a program accredited by the Council for Accreditation of Counseling and Related Educational Programs. Subpart 2 provides the standards for the department to approve or deny the initial QRC application. This includes the possible reasons for denial. DLI has a 60-day deadline under this possible language to make a decision, although the turnaround on most files is probably a week or two. This lets the applicant and DLI know a timetable when a decision must be made. It also mirrors the current language for QRC intern approval in the current rules in Part 1500. If approved, the now QRC receives a registration number as shown on line 312 of the draft for discussion purposes. Registration expires a year from the date an application is approved, which is the same as in current rule. Subpart 3 describes the requirements for a renewal application. Much of the information that is required to be included, like firm information and affirmation of residency or being within 100 miles of the Minnesota border, is like the initial application information. There is also added information on the master's degree option described earlier. It requires 20 CEU credits. Also, this subpart reminds the QRC that they cannot provide rehab services if their registration has expired before their license is renewed. Subpart 4 explains what could cause a gap in registration and when an applicant may need to attend additional training if that gap is greater than 12 months. Current rules in Part 1400 would require attendance at training if an applicant was inactive or did not renew their registration for 2 years. The current rule talks about 2 years, and this new timeline is just to ensure that an inactive, unregistered QRC is kept up to date with the information needed to best assist an injured worker. Subpart 5 discusses the standards for approval or denial of the renewal application, including the process for reapplying if there's a denial and it was final for the prior application. This process is like the initial application. The added information here just describes the process for submitting a new application if there was the previous denial and all appeals were exhausted. It also includes information on when the QRC registration expires, which is based on the timing of the approval of the previous application. Subpart 6 concerns the appeals process for a denial. The appeals process is standardized throughout the rules, but involves a written request and referral to the Rehab Review Panel under statute. It is nearly identical to the process in current rule in Part 1500, with minor changes to make it more plain language. So that was Part 1510 for QRCs, and once again, we are now moving to a new section of the rules, this part in 1610, which is for QRC firms. If you're still following along on the possible rule draft, this is on line 423. And this proposed language, much like we've seen in other sections, would replace the current language in Part 1600 for QRC firms. There are 6 subparts here as well, discussing the requirements for registration for a firm throughout. Subpart 1 describes the requirements needed for a QRC firm. For example, a firm must be owned by a QRC or an entity registered with the Minnesota Secretary of State. A firm must also maintain an office in Minnesota or within 100 miles, and if not, there will be a period after the effective date of the rules where DLI will provide notice to comply with that requirement. The firm is also responsible for making sure that employees who provide rehab services attend updates and orientation sessions such as this, and notifying DLI of any employee changes. Most of the requirements that you are seeing in this draft are in current rule in Part 1600, and there are also some cross-references to other parts of the rules so that all the requirements are noted in one section. And again, that is part of the department's work to make sure that each section for each entity or individual can be used standalone. Subpart 2 describes the staffing requirements for a QRC firm. And these requirements, including that at least 60% of employees providing services to injured workers must be QRCs or interns, are included in current rule in Part 1600. Here, the possible rules are just adding this in its own subpart rather than having it in just a long, drawn-out paragraph in the section. Subpart 3 lays out the required information for an applicant for firm registration. So this includes information on the individual, if the firm is owned by an individual, and on the firm itself. Many of these requirements have been part of the registration process already, and now we're just adding it into the rule itself. Note that the circumstances described previously about that gap for QRCs would also apply here. Subpart 4 describes the approval or denial process. This is similar language to the other sections of the rule, so this should look familiar. The draft includes the language in multiple areas so that the sections that apply to each person or entity can be read individually, and we've noted that previously. So when you see the repeating language, that's why it's repeating, and that's based on feedback we've heard about other rules where sometimes those references to other sections can get confusing. That same reasoning is going to apply to subpart 5 here on the appeal process, as we've discussed previously, and how the appeal process works with the written notice and potential transfer to the RRP if needed. Finally, subpart 6, which is on lines 541 of the draft of possible rules, is cross-referencing a current requirement in part 1802 of the rules about transferring a rehab plan when a firm's registration expires. So if a QRC firm's registration does expire, the QRC who owns it or a QRC member of the management staff must ensure that an active plan is transferred as required by that section. So we've now reached the final specific new section of the possible rule draft. And if you've been following along, then you're probably going to be able to guess that Part 5220-1710 is about rehab vendors. And this is meant to replace and provide a little more guidance on the registration process for QRC vendors, and is found on lines 547 through 650 of the draft for discussion. Again, we're going to go through the subparts in a little more detail, and there are 4 subparts here. Subpart 1 is again going to discuss the requirements for a vendor to meet while they are registered. There are some requirements, such as the office requirement and attendance at trainings, that are similar to those for a firm. And some other items to point out are that a vendor can only provide services under an approved rehab plan and must communicate with the assigned QRC or intern regarding all services. That the vendor must provide case files to the QRC firm within 2 weeks of closure, and that the vendor cannot employ or engage the services of a QRC. Many of these items are likely going to be familiar to those that know the requirements in current rule. Subpart 2 details the information needed as part of the registration application. A vendor application will consist of a lot of the information we've touched on previously regarding ownership and employee information. Some of that is outlined here, and note that the same circumstances about that gap that was mentioned earlier for QRCs and firms would also apply for registration for a vendor. Subpart 3 discusses the approval process, and you're seeing, it's essentially the same process as we saw for the QRC firm. So again, it meant to be the standalone for vendors is why it's here in its own subpart. And subpart 4 discusses that appeals process, which again is going to look familiar. You'll start seeing these. Basically the same as for the QRC firm that we discussed earlier. That's really it for the new sections as a broad overview here. The rest of the rule changes, and if you're following along in the draft, this is really from line 652 to the end. This is pretty much all technical changes. For instance, the change in 5220-1750 notes that the Vocational Rehabilitation Unit, or VRU, at DLI is exempt from the fee requirements in the rules. That's actually not different from current rule as noted here. It's just moving it because of changes that are being made elsewhere in the rules. Otherwise, the changes in other sections through 1900, so 1801 and 1802 and 1900, these are all changes made, as noted here, to resolve the use of the term registered rehabilitation vendor. And finally, as noted previously, the draft proposal would repeal current rule sections 1400, 1500, 1600, and 1700, all of which currently describe the registration process for persons or entities that we've mentioned. And again, the department's goal with the draft possible changes here is to reorganize those requirements so that each intern, QRC, firm, or vendor can clearly see what is required of them individually or as an organization in the rules when they are going through the registration process. If you'd like some more information about these rules, I'm going to provide a couple of additional resources that may be helpful here. So there's a couple links on the slides here, including to current rules, the statute, and in particular that statute that involves rehabilitation, and the DLI website. But if I'm going to point to one item, it's our rulemaking docket page. That's the top link here. That includes a link to the draft version of the rule and other information about the rulemaking process. And you can also sign up to receive rulemaking notices on the department's website and receive notices about updates for all workers' compensation rules. The department will continue to post any updates related to this rule on its rulemaking docket as required. If there are any questions that did not get answered during the presentation in the chat, please feel free to direct them to the chat at this time. Otherwise, I will thank you all for your attention for this presentation. My contact information is listed here on the screen, and you are welcome to contact me by email or call with any questions about the rulemaking process. Thanks again.